All right, this is, Mr. Baez, your emergency motion to preserve or inspect evidence and participate in forensic testing. Why don't you go ahead? First of all, is everybody here? Has everybody been noticed? We have the state attorneys here. Anybody here for the county?
Yes, Your Honor.
Okay, and any other necessary parties?
Your Honor, I represent the Sheriff's Office.
Okay, all right, thank you. Go ahead, sir.
Good morning, Your Honor.
Good morning.
Jose Baez on behalf of Casey Anthony. First off, I'd like to, if I may approach with four of my co-counsel, I will clarify a motion for autopsy, which I provided counsel with a copy of. My co-counsel, Ms. Kenny Bodden, will be covering some of the forensic aspects of my motion. First off, we're here in reference to the possible preservation and testing of evidence. And if Your Honor recalls, we have a current order as it relates to DNA. And due to the possible findings that occurred yesterday, we believe, due to preservation of evidence issues, that it would be important that the court address these matters as to our ability to inspect certain areas, specifically the crime scene or alleged crime scene. In addition to that, we're also referring to the autopsy and any future DNA testing. I'm going to go ahead and defer to my co-counsel to lay out specifically for the court exactly what it is that we'd like to cover.
Your Honor, if I may, I have an emergency motion that does not refer to anything about a crime scene. Is there a subsequent motion that I have not seen?
No, this does refer to the crime scene.
Oh, okay. I just want to make sure I haven't missed something.
No, it does not, and we're not going to discuss the crime scene. This has to do with DNA testing and the autopsy. And preservation of evidence, which I would expect would happen in any event.
Of course.
But go ahead, counsel, whichever of you want to speak on the motion.
Good morning, Judge. Thank you very much for your courtesies in allowing my pro hac admission here. I'd like to cover specifically the autopsy, and I have read the state's response that they served on us this morning.
Which I don't have. Is there a response?
That's Orange County's response, not
Orange
the
County.
state's.
I apologize.
I do have a copy for the court, Your Honor. May I approach?
Yeah. All right, thank you. I'm sorry, go ahead, counsel.
Yeah, thank you, Your Honor. But in any event, at least we worked that out. One of the lead things, obviously, that we read, and obviously Your Honor has seen no secret, that there was a missing body of a child that was found. Right now, the body, we assume, is still in the possession of the medical examiner's office from the reports. One of the things that we want, and it can be either or, Your Honor, and we're going to leave it to your discretion, but we want to make sure that our clients' interests are protected, is to have somebody observe, and it has been done in Florida before, observe the autopsy for the defense. And let me just say, in regard to that, Your Honor, we understand that this is a very serious proceeding, and we wouldn't want to have anyone fly by night in. So we are in the process right now, and she is on a plane from Montreal flying Dr. Kathy Reichson, who is a world-renowned forensic anthropologist. And the reason why we took that step is from the news media reports that the remains that were found may have been partially skeletonized. We think that in order to be able to properly defend our client, it would be important to see the body in situ at the medical examiner's office, not to interfere with anything the medical examiner is doing, but to have our anthropologists and also, preferably, a medical examiner. We have Dr. Werner Spitz on call, who is one of the senior people in the field of forensic pathology, both in the United States and the world. Again, to observe the autopsy, to see what information that may be beneficial for due process purposes, to see and maybe even suggest other things that may be done that may be helpful, because science, which is part of the autopsy, should be open to everybody. Autopsy should be open to everybody. I know Your Honor has not talked about the crime scene, and before I do want to just touch upon it, because it's not right yet because the crime scene hasn't been released, but we do expect to file a motion on that because we do have Dr. Henry Lee on call to come down with regard to that. But the other person that we'd like to bring in would be a Dr. Timothy Huntington from Nebraska. Dr. Huntington studied and learned and is a diplomat of the American Board of Forensic Entomology. He learned from Dr. Neil Haskell, who is also one of the world-renowned entomologists, and we understand with any skeletonized remains that would be important to see and observe any insect activity that exists now. The other alternative would be to ask the court, if you do not let us observe in situ the autopsy and the reports now, to leave the body at the medical examiner's office and let us come in at the medical examiner's office, and we would be glad to give access to the state to be with us, to have our experts then to do a second review of the body, both Dr. Spitz, Dr. Reichs, and also, as may be necessary, the forensic entomologist, a second review, and we'd be happy to, because we believe signs should be open, so we're not fearful of anyone watching, as long as there weren't videotapes taken, and we of course would agree to the same thing, that we wouldn't want videotapes taken. This is all in an attempt to make sure that our clients' due process rights are protected, that we get the information sooner than not later, that we see the x-rays that are taken as the body is in the medical examiner's office, not maybe later after things have been done to it, in order to make sure that our clients' fair trial interests are protected. Now, I know Your Honor said you weren't going to discuss the crime scene, but I just want to put Your Honor on notice that we do have Dr. Lee, because one of the things that Mr. Baez was going to ask for is that perhaps after the state finish with the crime scene, finish what they're doing, is that they at least hold it for us so that we could be the first people in to see it. And again, they're welcome to come with Dr. Lee and our experts, so that the press isn't trampling in it, that we get to see it as pristine as possible.
Your Honor, may I object? The court's already indicated we're not here to discuss the issues about the crime
objection. I understand a motion will be filed.
Yes, the motion will be filed. Now, I'm just trying to give the court heads up regard to that, because that would probably be sooner than later, depending on when they're released. Because obviously, once they release the crime scene, there's
Your Honor, I just objected, and counsel is now proceeding on the matter, and I would ask the court to instruct counsel to limit her arguments to the motion before the court.
Let's continue on this motion.
Yeah, let's go on with the autopsy. Those are the two issues with regard to the autopsy. Either to have somebody observe the autopsy firsthand, which would be our preference, and again, not to interfere at all, and we're trying to bring people here that do have credentials, so that and that they're known by the people in the medical examiner's office. I think that Dr. Reichs needs no introduction. And secondly, if that is not amenable to the medical examiner, to ask the body to stay there and let our people come in the medical examiner's office to see the pictures, to see the x-rays, and to do a second review of the remains. Thank you, Your Honor.
Yes.
I would defer to the county, who's filed a response at first, and I'll speak after.
This is Ms. Gappin?
Yes, Your Honor. May it please the court, I'm Tammy Gappin, Assistant County Attorney. I represent the Orange County Attorney's Office and the Orange County Medical Examiner's Office. And it is the county filed its last-minute motion due to the last-minute motion filed yesterday. And the county's contention is that this issue is not ripe. The defense does not have standing to even make this motion, as the remains have not yet been identified. It's unknown whether the remains belong to that missing child, Kaylee Anthony. At this point, we don't know who that person is. There's speculation, of course. There's anticipation, of course. However, we don't have the scientific response saying who it is.
It occurred to me, once that's known, though, isn't it too late to grant their wish?
No, Your Honor, and here's why. They don't have standing, first, to bring that in. Second, Chapter 406 of the Florida Statutes is the Medical Examiner Act, and it establishes the medical examiner as the sole authority for determining which examinations, investigations, autopsies, and laboratory exams are necessary for each case involving the death of a human being. In a case like this with unidentified remains, the first priority of the medical examiner's office is to identify the body, and that's specified in Florida Administrative Code 11G-2.002, subparagraph 1. Also in the Florida Administrative Code under 11G-2.0021D, the medical examiner is required to retain samples for possible DNA profiling, in addition to other examinations, as a regular function of identifying a body. The Florida Administrative Code also requires a medical examiner to seize and retain physical evidence needed to identify the body as well as determine a cause of death, and that's under Florida Administrative Code Section 11-2.004, subparagraphs 2 to 4. And the Florida Administrative Code also provides for requests for independent examination and analysis of the physical evidence in the custody of the medical examiner, and the code places complete control of such examinations in the medical examiner, and that's under Florida Administrative Code Section 11-2.004, subparagraph 5. The laws are very clear on what the medical examiner's office is required to do, what they normally do as a normal course of their business. Having an unidentified body being part of a criminal investigation is not a brand new situation. They have procedures in place. The county argues that the medical examiner needs to have the dignity and integrity of their office preserved in doing the exams they need to do without having the circus atmosphere brought in with all manner of different individuals to watch an autopsy or any exams that are done on a body that may not even be pertinent to this case. In addition, the county medical examiner is required to preserve all evidence. And in fact, because the remains are now in the hands of the medical examiner, they are more likely to be better preserved than ever before than they were prior to being discovered yesterday. So,
assuming I agree with you about those thoughts, what do you say about her request for a second review of the body?
I believe the Florida Administrative Code provides for that. And that would be under Section 11G-2.004, physical evidence, subparagraph 5, that states that requests for independent examination and analysis of physical evidence in the custody of the medical examiner shall be allowed by the medical examiner under his supervision and control in a manner designed to provide maximal preservation of the physical evidence. The only concern the county would have is allowing the criminal case to go forward as needed and allowing the criminal discovery process to go forward as it is designed to do. And the point is the medical examiner's office does preserve evidence, is designed to, these laws, these rules are designed to preserve evidence in cases just like this, and that the criminal process should be permitted to go forward as usual, and that everything come out in the due course of regular criminal discovery.
After your work is done?
Yes, after the medical examiner does their work.
Thank you. Would anybody else want to speak on behalf of the state of the county, the medical examiner?
Yes, Your Honor. Thank you. Anne Marie Delahanty with the Orange County Sheriff's Office. I agree with everything that Ms. Gappin just said, and wanted to add that this is an ongoing investigation until and unless the remains are identified as that of Kaylee Marie Anthony. We still have an investigation to do. At the point they're identified, then the court's jurisdiction kicks in. Right now, the jurisdiction is still with the sheriff's office and the medical examiner's office, who has control of the body. I don't know that the medical examiner's office will be making an identification of the body. It's probably going to be a DNA identification, and that probably will be the FBI. So once they're done with the autopsy, I don't know that the body will be staying there, depending on what the FBI needs or doesn't need to do their investigation and make the identification. So right now we have an ongoing investigation. We don't have an identity on the body, and once that is done, then it kicks over to the state attorney's office and discovery issues and the court's jurisdiction. So we do object to any order that would stop us from doing the proper investigation and identification that needs to be done.
Thank you.
Thank you.
Your Honor, maybe. Your Honor, is it?
Forgive me, I'm sorry. I didn't realize the state wanted to speak. Go ahead.
Yes, thank you. Your Honor, first of all, to correct opposing counsel, there is no due process right to discovery in the state of Florida. It doesn't exist. The only right to discovery is the right granted by Florida Rule of Criminal Procedure 3.220. There is no provision of that rule that would permit this type of attendance or inspection. So in addition to counsel for the county and the sheriff's position that until this body is determined to be that of Kaylee Anthony, the defense has no standing, our position would be that even when that day does come, the defense has no right to attend the testing of any evidence. Now, taking this issue one step further, we also have the provision of Florida Statute 406.135. This is a statute that deals with the confidentiality of photographs, videos, or audio recordings of autopsies. Now, this rule does not prohibit what's being asked for, and I'm not suggesting it does. It does, however, state a public policy that we have accorded autopsies a higher level of respect than any other type of examination in this case, or in any case. I will tell the court that it is our intention, if in fact the identification is confirmed, to ask the court pursuant to this rule to restrict access to those, to not make them public record. But we'll get to that later. The point I'm trying to make here is that that additional respect that we give to the dead carries over into this case. What I don't want to see, bluntly, is 24 hours after viewing an autopsy, a defense expert on a national news show describing this child's remains. When Dr. Henry Lee examined the vehicle, something as minimal as that, within 24 hours he was on a national news show describing what he had seen, and the specter of that is nauseating to me. And I would submit that this statute states a public policy of respect. Going one step further than that, there has been no testimony presented to this court that a completely adequate examination by the defense cannot be done after the autopsy is completed and based upon photographs. There has been no suggestion that it cannot be fully and adequately done. And until the court is given some exceptional circumstance, I would submit the court should not consider something as egregious as allowing strangers to be present for the autopsy of a young child. Again, the rules are adequate in terms of allowing the defense to examine evidence when the state is done, when the law enforcement is done, to fully reveal all aspects of a test that's been done, and we will do that. The point here is defense counsel who just spoke also said that she wants the court to allow their experts to suggest things. So apparently it's not just observations, it's also interference or directing the autopsy. I would just submit that the discovery rules in place are adequate to allow the defense to fully prepare to respond to this information, and that any order by this court to interfere in any way in that process, to be involved in any way in that process, again, is beyond the court's jurisdiction and also in violation of the spirit of 406.135.
Okay. Ms. Bye, did you want to respond?
Yes, thank you, Your Honor. Your Honor, two things dealing with the issue, and I'm going to stay on point and not deal with the attacks about spectacle and all, because what we are trying to do is dealing with the issue of preserving our rights of the client to get the best information, the best defense at this point. So I'm not going to even get into that little morass there. But is the county saying that there has not been a tentative identification? Because the normal procedure in these things is the medical examiner does a tentative identification based on dental records, forensic odontology it is called. It's a fancy word, but some, I think, charge more when they're in private practice, Your Honor. But it's for teeth. Additionally, Mr. Baez was called yesterday by the sheriff, and he can correct me if I'm wrong, and told that the anthropological measurements were correct on the child for her being Casey Anthony, that the hair color was correct, and that they were proceeding as if this was Kelly, little Kelly Anthony. So if there has been no tentative identification, it would be disingenuous for them to get up there and say that because they're waiting for a Quantico and DNA or whatever lab is doing the DNA, and I'm not sure it is the FBI lab, that's up to them, to make a final identification, which DNA always has to occur after an autopsy, because you take samples for DNA at the autopsy. So if there's a tentative identification, we should be aware of that, because that impacts upon the standing issue. And then again, we're also asking not to desecrate any remains or be disrespectful. That's why we're here, for Your Honor. That's why we're trying to have Dr. Spitz and Dr. Reichs come in, who I am sure the medical examiner's office is familiar with. to try to either observe or go there, especially if there's been a tentative identification, and see what they have in situ at that time. And I would point out that if the prosecution is waiving their right, that what I expect to hear at trial, that they'd be waiving their right to examine our experts. Well, you only looked at pictures, doctor. You only looked at pictures, Dr. Reich. You only looked at pictures, Dr. Spitz. So your testimony is somehow impaired. If they're waiving that right, that should be considered. But if they're not waiving that right here today, then that argument should be rejected that pictures are as good.
Okay, thank you. State back over to you or whoever, I suppose maybe the county. Has there been a tentative ID? Can anybody inform the court?
I can inform the court. I just confirmed that with Detective Allen. There has been no tentative identification.
All right. Here's what the court's going to do. I can't address everything that's come up here today. The body of the motion that was filed, specifically paragraph 5, says if the body is determined to be that of Kaylee Marie Anthony, then the defense would request that their own experts be permitted to be present during any forensic testing done. I guess we're requesting to be present at the autopsy. It says including but not limited to DNA testing or the autopsy. That request is denied by the court. There has not been a tentative ID. I suppose there's a standing and a jurisdictional issue before the court, but specifically the court may re-examine this on the defense or Ms. Bodden's motion regarding a second review of the body after there has been an identification and an autopsy. But the bottom line is, at this point, this would do nothing more than interfere with the obligation of the medical examiner to go ahead and do what it is they do. And the medical examiner's office, those aren't litigators. Those are people that have a statutory duty to find out what really happened and find out the truth. At the same time, I can certainly understand the defense posture, which is they want to have their own look at this rather than just view pictures. I'll address that later, but for now, the defense motion is denied.
Your Honor, may we be advised when there is a tentative ID so we can refile back with you? Could there be an order that Mr. Baez is advised when there is a tentative ID as opposed to a final?
County, you want to be heard on this? Tentative versus final ID?
Final would be DNA, tentative would be something less, or...
Okay. All right.
I'm not sure how I apologize, how the medical examiner's office designates tentative.
She's discussing it, I believe.
Your Honor, on behalf of the Orange County Medical Examiner's Office, the medical examiner would be the ones making the identification, and they would notify whichever appropriate parties need to be notified. So whoever needs to be notified, they will notify.
After the preliminary ID?
I don't know that, Your Honor, I don't know that exists in the nomenclature of the medical examiner's office. I've never heard of that used, but perhaps I'm mistaken.
Somebody want to enlighten the court? Are there two IDs in Florida? Or will the autopsy be done and then an ID?
It would be the definitive identification. Once they are sure who it is, then they will notify appropriate parties.
Can you give the court a rough time frame on that?
No, Your Honor, it's in the hands of the FBI.
Okay. Not even an approximation?
No, sir.
Okay.
Judge, just a moment. The statute says the medical examiner does it, but now it's in the hands of the FBI, and the FBI has no third parties looking at them at all. You cannot get into the FBI lab, and we're all aware of some of the problems that have existed as a result of that. So I think this is a handoff here. The medical examiner either believes it's the body on things that they use, and then sends the DNA for more testing. But then to hold up, are they saying they're going to hold up the body for 2 or 3 weeks if that's how long it takes?
They're not saying, but the court's not going to interfere with their function. Here's the official ruling. I'm going to have them notify you as soon as a final identification has been made. This hasn't been before the court before. I see no harm in that happening. Evidence will be preserved for you to look at in some shape or manner. The court, again, is not exactly ruling on that. I understand your request for a second review of the body, and I have not specifically ruled on that. We'll deal with that later. But promptly, the defense counsel should be notified upon final identification of the remains of this body. And I think that concludes our business today.
Judge, may I address one issue, if I may? For court efficiency purposes, the last thing I want to do is interrupt Your Honor's calendar as far as to have more emergency issues, due to the fact that we're dealing with a situation where these forensic items have passed a certain period of time, and time is of the essence. I would request that, should the defense decide to file a motion for a second autopsy, that we are allowed to do that via motion rather than having another hearing, unless, of course, Your Honor has an immediate...
I'm not following you. Are
Well,
you?
what I'd like to do is be able to handle this via written motion so we can get it done immediately, rather than
Have a
have
motion without argument?
Judge, excuse me, I just consulted with co-counsel and with the sheriff's office. If this is the issue of the crime scene, we have no objection to turning the crime scene over to the defense for whatever they want to do as soon as the investigation is done. So counsel doesn't need to file a motion.
There we go.
All right, that's it. And again, can you tell us about when that'll happen?
I don't. I'm sure we can't, because obviously we don't know what we're going to
I know
find.
it's ongoing. I'm
But-
just pushing to get a time frame so that the defense will know when to have folks here.
I'd hate to give you one because it would just be a total guess.
I understand. As soon as feasible, that crime scene needs to be made available to defense experts to review. That's not on the docket today, but we basically have,
That's just by agreement of the parties.
however rare they are, that's fine.
We have that in the minutes.
However rare they are.
Yeah.
And by agreement, that would mean that they're going to preserve it until we get there? I mean, if they...
I'll
Hopefully.
clarify. What that means is that when they're done, they're going to call you and say, we're leaving, and then it's yours.
Well,
That's my contemplation.
that agreement then is not quite, because we'd hope to get some notice, because we have to fly people in. If you're telling us they'll be finished tomorrow, we'll fly them in. We're
we
not
don't-
trying to be difficult, we're
Okay,
trying to
here-
work with them.
Okay, well, hang on.
We'll work it out.
Okay, but just to be sure, what I don't anticipate happening here is the phone call and then a neighborhood full of people trampling through the area. So I'm contemplating some reasonableness aspect of this, okay?
And obviously, that's our intention. We're not going to
I love good intentions,
abandon
but-
the crime scene and say, come on and let's have a party.
Right.
We don't operate that way.
I'm counting on your cooperation
Thank
here.
you.
Thank
And
you.
that's what we're
Thank you,
trying to
Judge.
do.
Thank you, Judge.
We're done.
Apparently isn't very successful. We try to cooperate.